Pamela Pio versus Nancy Gerler.
This case opens with tension already humming under the surface. Two women, one home, and a rental agreement that fell apart long before either of them stepped into Judge Simpson's virtual courtroom. What you're about to see is a classic collision between a landlord who says she has done everything by the book and a tenant whose life circumstances have spiraled into a storm of illness, disabilities, and sheer survival mode. Judge Simpson, known for his blunt, dry, sometimes hilarious delivery, steps in trying to untangle a mess that started with a verbal month-to-month agreement and escalated into thousands of dollars in alleged unpaid rent. But here's where the story twists. The tenant claims she tried to pay. Agencies tried to help. Money was supposedly offered and declined. Is that a red flag, a misunderstanding, or something deeper? And when you mix in claims of long COVID, disability, and environmental sensitivity so severe she says she literally fries near wireless signals, this case becomes anything but straightforward. Across the next moments, you'll watch Judge Simpson walk a tightrope, respecting medical challenges, honoring landlord rights, and trying to keep order as both sides bring wildly different realities into the courtroom. Stick through this one, because the deeper it goes, the more complicated it becomes.
Hang on. Hold on, counsel. I'm not going to worry about it at this point. I'm just trying to get through these. Come on. Your name?
Pamela Pio.
All right. Miss Gerler here?
She's on the phone.
No, she's on the.
I do not know how this got muted again, Your Honor. I believed I was on unmute. I have been present.
You're good right now.
Okay.
All right. Where are you folks in regard to this case? Did you receive a copy of her answer?
Yes, I did. Yes, I received it on the 13th. So I'm the owner of the home at First Way, Dexter, Michigan, where the defendant is now occupying the first floor. I'm very nervous in this setting, so that's why I wrote everything.
That's okay. Me too. Go ahead.
Okay. I'm seeking possession of my property and I want the defendant to move out immediately. We have no lease. On September 23rd, 2021, the defendant and I made a month-to-month verbal rental agreement, and she agreed to pay $995 a month on the first day of each month following the first payment.
The plaintiff wastes no time laying out her position. No written lease, a month-to-month verbal agreement, and now an urgent demand for the tenant to leave. Legally, month-to-month tenancies give landlords flexibility, but they must follow proper notice procedures. She claims she did exactly that, issued a 30-day notice, and now wants possession plus a money judgment. But here's the issue Judge Simpson catches instantly. A 30-day notice can't be used for a non-payment action. That's a legal technicality many landlords overlook. You can't use the same notice for two different legal categories. And when the judge interrupts her, you can almost feel the moment her strategy hits a wall. Still, she doubles down. She wants both possession and money. That's allowed, but it means the court must treat this as a termination of tenancy rather than purely non-payment. Subtle but important difference. Question to the viewers. Should landlords be required to provide written leases to avoid situations like this, or is a verbal agreement enough responsibility for adults?
October 4th of this year, I gave the defendant the proper 30-day notice demanding possession of my property because of non-payment of rent.
Well, okay, let me stop you there.
Okay.
A 30-day can't be the subject of a non-payment of rent action.
Okay. So.
All right. Do you want her to move or are you just terminating her tenancy? I mean, are you terminating her tenancy and want her to move or do you want her to pay you?
I want her to move and I want to also have a money judgment. So I can do that?
Yes, you can do that.
Okay, that's what I want.
Okay. Go ahead.
Yeah, and I'm seeking a money judgment from the court for all back that she owes me as of December 1st, 2023, which is $11,995 plus court costs $215 and service fee of $68.
So how much is your
So the total
claim?
money judgment requested from the court is $12,000 $278.
All right, Ms. Gerler, what do you have to say to that?
Your Honor, when I first moved in, it was to be a temporary arrangement. I had another place lined up that did not end up being represented appropriately. It was to be vacated and renovated. Didn't happen. I have attempted along the way to give Ms. Peel, the plaintiff, money. I became extremely ill with COVID, which I have long COVID, along with 2 other disabilities.
Now the tone shifts dramatically. The tenant launches into a detailed account of how everything unraveled. A temporary stay that turned permanent, a rental she expected to leave soon, and then the domino effect of severe illness. Long COVID, disabilities, inability to work, agencies offering funds, and most importantly, she claims the landlord declined rental assistance that would have covered what she owed. Legally, landlords are not obligated to accept agency funds, but judges often take such refusals as signals that the landlord prefers possession over payment. That matters. It shapes how the court interprets intent. The tenant paints a picture of someone overwhelmed by health issues, bureaucracy, and a housing crisis. But here's where viewer judgment gets tricky. Is this genuine hardship or avoidance wrapped in sympathetic language? Her explanation is emotional, but courts don't rule on emotion. They rule on timelines, documents, and legal requirements. Would you have accepted the agency money if you were the landlord, knowing it would pay off the arrears?
When I became behind in rent because of illness and sought help from local agencies, the plaintiff was offered money from Faith in Action, and she declined those monies. And there were other monies from other agencies that would have been available that would have satisfied my arrearages at that time of $2,985. Declining those monies led me to believe that she simply wanted me to move out. So I tried to start packing possessions, became ill with COVID again. I have, in the court documents, outlined to you the many times since then that I have been afflicted with every COVID variant. I already have a serious extreme condition of electrohypersensitivity that I cannot easily find a place to live. I cannot live in group settings, be exposed to Wi-Fi, wireless meters, be near cell towers. I need a rural environment. I no longer have a vehicle. I cannot use cell phones, smartphones, computers due to my electrohypersensitivity, and I thank the court for granting this Zoom appointment at the last minute, since I was not supplied the forms necessary in the personal and mailing service I received, and was actually waiting because in our December 1st hearing with Judge Barr, he informed the plaintiff that she had filed incorrect paperwork and needed to refile. So I have been waiting for that paperwork to come, which I don't know if something changed and was not necessary.
This section hits a level of complexity rarely seen in simple landlord-tenant disputes. The tenant introduces electrohypersensitivity, an unstandardized medical condition that severely complicates housing options. She claims she cannot live near Wi-Fi, smart meters, or cell towers, requirements nearly unavoidable in modern life. In court, these conditions don't erase legal obligations, but they do influence the judge's approach. You can hear Judge Simpson trying to parse through medical claims, paperwork disputes, prior hearings with other judges, and contradictory information from attorneys. It's classic courtroom fog. Each party believes their version absolutely, but nothing lines up perfectly. What stands out is the growing sense that this case is not just a rent dispute. It's a collision between medical vulnerability and property rights. Judges tread carefully here. Empathy matters, but statutes cannot be bent simply because circumstances are difficult. Still, the viewer should consider, when a tenant's disabilities make relocation nearly impossible, How should courts balance compassion against the landlord's rights?
But I
What
am
incorrect
now,
paperwork? I don't have a notice to that.
well, and that's whatever happened, Your Honor. That's what I heard in court, and I'm not privy to what happened thereafter. I am chronically ill, Your Honor. When I
Okay.
get well,
Ma'am,
I
hold on.
cannot work.
Yes, ma'am.
I spoke with my attorney counsel yesterday, and she said my paperwork was fine. I think it was just not clear to Judge Barr what I wanted because I didn't know how to present my case. So,
Well,
but
yeah, I actually see what Judge Brett is saying right now. Well, you filed two different notices. That's why. I got it. It's fine. I think. Hold on. That's not that one. Right. You filed two different ones, but you've got, it appears to me, the correct paperwork.
This moment brings a significant legal clarification. Despite earlier confusion, Judge Simpson determines the landlord did file the correct paperwork. The confusion likely came from procedural misunderstandings or poor phrasing, not uncommon when self-represented parties file eviction actions. The tenant insists the previous judge indicated the filings were wrong. That contradiction puts the current judge in a delicate position. He must acknowledge her confusion while restoring order to the legal framework. His tone sharpens, not out of disrespect, but because he needs clarity. Courts cannot operate on assumptions or misinterpretations. This is where Judge Simpson's dry humor cuts through. They know more than us little country judges up here. He uses sarcasm to highlight how unreliable secondhand legal advice can be. For the audience, notice how easily eviction cases derail due to paperwork confusion. One wrong form can delay a case by weeks or collapse it entirely. Precision matters.
Your Honor,
So-
just to respond, that's what I heard from the judge. And my legal
Yeah, but
counsel,
this is another judge saying that that's wrong. It's correct.
and that's fine. I have no problem, but I was
Okay,
waiting
good.
on that paperwork. I know that the plaintiff is someone who tries to do things appropriately, but what did not happen appropriately with this home that has been a long time rental is that there is no certificate of compliance on file with the township. And the
Okay, so
application-
when are you going to move then?
Your Honor, I have had to deal with all the demands of the court, so I cannot explore that yet because I was required to apply for SER with the DHS, which was declined. I have contacted every agency available to me thus far.
Ma'am, do you understand she doesn't want you to pay rent and stay? She wants you to leave.
I understand that, sir, but to comply with the court and the paperwork required for this hearing, DHS, that's where I have put my first attentions. I have been packing and moving things out of the house, which they have witnessed, but because of my extreme sensitivities, it is not easy for me to find a place where I can live safely. I have just recovered from my last bout with COVID, which has severely impacted me for the last 4 years and created these issues. And I have also...
Ma'am, I understand all of that. The question becomes, when can you move?
That is a question mark to you and me both, Your Honor. I do not know. I have nowhere to go. I am solo in this world. I have no vehicle. My car broke down June of 2022. And my situation is not a good one because of chronic illness. My energy is not reliable, and sometimes 12 hours in the bed.
This is the emotional center of the case. The tenant, clearly overwhelmed, tells the judge she simply doesn't know when she can move. Her health, mobility, and lack of housing options make eviction feel like a cliff edge. Judges hear hardship every day, but the severity described here, Long periods bedridden, lack of transport, repeated illness pushes the boundaries of what the court can reasonably address. Yet Judge Simpson must also uphold property law. A landlord cannot be forced indefinitely to house someone who isn't paying rent, no matter how sympathetic the circumstances. His tone balances acknowledgement with firmness. Compassion, yes, but the law remains the law. This moment exposes the brutal reality of eviction cases. One person's dire medical condition does not cancel out another person's right to reclaim their home. Would you say the judge should grant more time because of her health, or prioritize the landlord's immediate possession rights?
Okay, ma'am, I can appreciate all of that. But you also have to understand that the landlord is entitled to her premises back.
I understand that they request their premises back, and I have an appointment with Hawk on Monday. To what degree that will help, I do not know at this point. I have been unable to find assistance from anybody because they say I am not sustainable, because I am now forced to live only on my Social Security income, the
Okay,
house line.
Okay, ma'am. Here's what I'm going to do, because this has got to. I understand the difficulties that you're telling. I also understand that the landlord needs to resolve that. So I'm going to set this for a trial. You've raised some issues in your answer, but I'm going to set it for a yes, ma'am.
When I talked to my attorney, she said that there is no requirement for the compliance regulations in Webster Township where I live. And she's an attorney from Dexter. So.
Oh, they know more. They know more than us
Oh.
here, us other country folk from Pittsfield, or what?
I guess. I don't know. That's what she said. Is that correct?
What?
That's what she said.
I don't know. I guess she's from Dexter, so she knows more than us.
Township does
We're
not
just
issue.
little country judges up here. Ma'am.
I actually called the zoning person too. She
Okay.
said,
And she said, yeah, probably
She said-
she agreed.
I'm having difficulty hearing, Your Honor. Could that be repeated?
No. Okay. She went to Webster Township. The issue regarding the certificate of occupancy, it really isn't an issue because they don't require it for rental properties in Webster Township.
Here the judge dismantles another major argument raised by the tenant, the alleged failure of the landlord to maintain a certificate of compliance. In many cities, landlords must obtain these certificates before renting out a property, but in Webster Township, they are not required for rentals. This is a crucial legal point. If certificates were required and the landlord lacked one, the tenant could argue the property was illegally rented, potentially halting or altering eviction proceedings. But with that claim invalidated, one of the tenant's strongest defenses evaporates instantly. What follows is a spiral of confusion. Legal advice from multiple sources, paperwork from agencies, forms handed out by legal aid. Judge Simpson cuts through it. None of that changes the core fact that the claim simply doesn't apply. This scene shows how tenants often cling to any perceived legal foothold, but courts deal only in what the statute actually requires.
That's the long and short of it.
I would like to know then why Legal Services of South Central Michigan gave me this form and checked
Okay,
it out.
ma'am.
They must
I
have
don't
obviously
know. You guys keep talking about lawyers. I've not met them. I don't know. All I know is this. You two are in front of me arguing a case. You have one position, plaintiff has another position. So here's what I'm going to do. I'm going to set this matter for non-jury trial. It will be in person.
Your Honor, that I hope you realize is not possible for me. I'm even being harmed waiting for 2.5 hours on my cell phone, which is on speaker remote
Ma'am,
from me.
then I don't know how I'm going to get you into court.
how is is it not possible for me to continue in this manner, sir? I have been before you to establish the severity of my condition. I become debilitated, incapacitated, ill. I lived in the basement of my prior home for 7 months because of radiation poisoning, and by necessity, where your court is located, there are many electronic communication requirements for police, fire, the cell tower, Wi-Fi for the buildings. I will literally fry and be unable to move. That's why I couldn't come today. This is not a fun scenario. And the landlords are well aware of my conditions. They had mitigated the house. They used Ethernet.
All right, ma'am. All right, look. Do you have any problem if I hold a trial and she appears by Zoom?
We now reach the operational challenge of this case. How can the court conduct a fair trial when the tenant claims severe harm from electronic exposure? She explains she cannot safely appear in person due to electromagnetic sensitivity, and even waiting on a cell phone for the current Zoom hearing is causing her distress. Judge Simpson, to his credit, tries to find a workable solution. The landlord agrees to a Zoom appearance which would accommodate the tenant's condition, but the judge also stresses that the process must keep moving. Courts cannot pause indefinitely. Thousands of cases depend on these schedules. We also see the judge's increasing fatigue. His docket is packed, emotions are high, and this case has demanded far more time than a standard eviction hearing. His final task is simple: find a trial date that works. The audience should note how courts juggle accessibility, fairness, and efficiency, all while managing real-world human suffering.
I guess not. I've been without income for a long time, and my preference is
Okay, look, folks.
Yeah.
There are a lot of folks out there that
everybody
are
has
having a
sad
hard time,
story.
and I get it.
Yeah.
Okay, I have to deal with it every Friday. So I don't know that I can help you with any of that right now.
Right.
I'm just trying to set a trial date. Do you
Sooner
have
the
any
better.
objection to her?
Tomorrow,
What?
tomorrow, the sooner the better.
I'm not coming in
Over.
on Saturday.
How
I'm just, it's not happening.
about Monday?
No. What? We can do when? What time? 1 o'clock on Wednesday? Oh, no, I can't do 1 o'clock. What time seriously can I do? Non-jury trial, December 20th, 2023.
At
9 a.m.
9 a.m. Okay. And
You need to appear in person. Ma'am, you can appear via Zoom.
right here?
Absolutely, that's where I'll be.
Okay.
And if I don't get this docket done, I'll be still sitting here from this one.
All right. Thank you.
Thank you.
Okay, thank you, Your Honor, for the accommodation for my disabilities. I appreciate your sensitivity to the matter and your humor.
Thank you, ma'am.
Bless you. I will sign off now.
All right. Lakestone Apartments versus Leslie Lewis, recall. Where's Miss Lewis? She's not here.
This case ends not with a verdict, but with a scheduled trial where the real decisions will be made. But the hearing reveals the core issues clearly. The landlord seeks possession and thousands in unpaid rent, relying on her month-to-month agreement and proper notices. The tenant, battling medical crises and profound instability, argues that assistance was offered, misunderstood, or declined, and that relocation is nearly impossible under her conditions. Judge Simpson walks a careful line throughout, acknowledging suffering without allowing the case to stall, rejecting irrelevant defenses, and reaffirming the landlord's legal rights. Eviction law is blunt. Compassion softens its edges, but cannot rewrite its structure. At trial, the judge will determine whether the landlord met all procedural requirements and whether possession and a money judgment are appropriate. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.